So today we are talking about non-public information. So Section 204A of the Advisors Act requires advisors to establish, maintain, and enforce written policies and procedures that are reasonably designed to prevent the misuse of material, non-public information by the advisor or any of its associated persons, including the misuse of material, non-public information about the advisor's securities recommendations and client securities holdings and transactions. You know, who would be considered an insider in this situation? This would be anyone who is a director, officer, investment advisor representative, and it can also be certain providers that you use, like accountants or attorneys. So these are all people that could be insiders. So trading on inside information is not a basis for liability unless the information is material. So material information is generally defined as information for which there's a substantial likelihood that a reasonable investor would consider it important in making his or her investment decisions, or information that is reasonably certain to have a substantial effect on the price of an issuer's securities. Material information can be positive or negative, and it can relate to virtually any aspect of a company's business or to a type of security. Material information does not have to relate to an issuer's business. So, for example, in Carpenter versus U.S., the Supreme Court considered material certain information about the contents of a forthcoming newspaper column that was expected to affect the market price of a security. And in that case, the Wall Street Journal had a reporter that was actually found criminally liable for disclosing to others the dates that reports on various companies would appear in the Wall Street Journal, and then whether those reports would be favorable or not. So information like that was deemed to be insider information that was material, and that gentleman was found criminally liable. So information is non-public until it has been effectively communicated to the marketplace. So someone has to be able to point to some fact to show that information is generally public. For example, information found in a report filed with the SEC or appearing in the Wall Street Journal or other publications of general circulation, or on a quotation service like Bloomberg, that would all be considered public. General release of information over a computer-based news service, in a corporate communication to shareholders, or in a widely distributed prospectus, followed by the passage of adequate time for the investing public to absorb such information, normally constitutes adequate disclosure. The circulation of rumors, however, even if they turn out to be accurate, does not constitute sufficient public disclosure. So information is not adequately disclosed to the public merely because a finite number of persons in the investment community may be aware of it. Material information that's communicated under circumstances where there's no indication there's been wide dissemination of it, or where the recipient of that information knows or suspects that it has been provided by an inside source, should be treated as non-public information. So there are two predominant bases for liability when it comes to insider trading. So under the fiduciary duty theory, liability arises when a corporate insider trades in the securities of his or her corporation on the basis of material non-public information. There's no general duty to disclose before trading on material non-public information, but that duty does arise where there is a fiduciary relationship. That is, there has to be a relationship between the parties to the transaction such that one party has a right to expect the other party will disclose any material non-public information or refrain from trading. In the Dirks versus SEC case that you see there, the Supreme Court discussed alternative theories under which non-insiders can essentially become insiders by acquiring the fiduciary duties of insiders. So a non-insider entering into a confidential relationship with the issuer through which they gain information, so attorneys, advisors, accountants. Non-insiders can acquire a fiduciary duty to the issuer's shareholders as tippies. So if they are aware or should have been aware that they have been given confidential information, who in turn violated their fiduciary duty to the issuer's shareholders. And actually a tippie's liability for insider trading is no different from the actual insider. So just because you are a tippie versus an insider, your liability is not going to be any different because the basis of being a tippie is that you knew or should have known. Tippies can obtain material non-public information by receiving tips from others or through conversations at social, business, or other gatherings. So we want to be careful when we're going to these different networking events or we are going to different conferences. You want to be very careful about what exactly you are discussing. And so drink moderately at such events. So I wanted to provide some examples of insider trading cases that have come up in the past. Penalties for trading on or communicating material non-public information are severe, both for the individuals involved in the conduct and for their employers. And that can include fines for the person who committed the violation of up to 3 times the profit gain or loss avoided, fines for the employer, disgorgement of profits, civil injunctions, and as I noted in the previous Supreme Court case, even jail sentences. So if you have a relationship with someone you think is an insider, you should exercise caution so that you do not inadvertently receive material inside information. One way to accomplish this is to tell the person that you have a relationship with that they should not disclose to you any material information that wasn't already previously disclosed to any analyst or that the issuer hasn't otherwise made available to the public. Again, you know, there's a lot of industry events that go on, and there's a lot of opportunities for comments on the side, and you just want to make sure you're not opening yourself up, that person or their employer, to any sort of liability because of the slip of a tongue. So, the examples of insider trading cases that have been brought by the SEC are cases against corporate officers, directors, employees who traded the corporation securities after learning of material developments in the business, friends, business associates, family members, and other tippies who traded the securities after receiving the information, employees of law, banking, brokerage, and printing companies who traded based on information they obtained in connection with providing those services. Government employees who traded based on confidential information they learned. Political intelligence consultants who may tip or trade based on material not public information. And otherwise, other persons who may have taken advantage of or misappropriated confidential information from their employers, family, friends, and others. So, you know, the big kind of example we always think of is Martha Stewart and the information she received from friends and ultimately the jail sentence she received for such trading activity. So I want to move on to Graham Leach Bliley. Alrighty. All right, I've got a question. Let me... Okay, Dave, go ahead.
A couple of questions about insider trading. Having the information, if you do nothing with it, is not a violation, correct?
Right. So, you know, the example being an attorney or an accountant having access to it, it's ultimately using that information to your benefit is where the line is kind of crossed.
The other just clarifying question I guess I have is, it seems to me fairly unlikely that most RIAs or IARs are going to have access to insider information. Everything's possible depending on what circles you run in or who you know or who's your uncle or something like that. But generally, this doesn't seem like something that, you know, 3 times a day you're getting access to insider information. Is that a fair statement?
Not necessarily. I mean, we see it with, you know, RIAs that deal with funds or where employees are allowed to trade securities in their own personal accounts, or where they are involved in outside business activities as a solicitor or working with another, you know, issuer in some position that may open them up to that non-public confidential information. So it's not common to the degree that we're not hearing about these things every single day, but certainly there are opportunities for it to happen. But again, that also depends on the individual RIA and the activities they allow their employees to engage in.
Okay. And is it also, it's less likely to, I would assume, occur with a publicly traded security on the NASDAQ or the stock exchange, but if you have a, like you said, a fund that you are an issuer for or finding advisors or investors for, maybe it's more likely that that's an area to focus on?
Yeah, I mean, I think when we're talking about the vast majority of RIAs, which tend to be smaller shops, the occasions for these kind of things to happen are where the RIA allows their investment advisor representative to engage in other business activities and to have securities accounts outside of the RIA. So I think that's where they may have a family member, a connection, you know, they're a solicitor or play some other role, and that's certainly where a lot of these opportunities will occur.
Okay. And this does not apply to things that are private placements. So like if there's an investment opportunity that's not a publicly available but a private placement, and does insider trading occur on those?
It depends on the fact pattern associated with the private placement. So if the private placement's been put together in response to some event that's happening with a company, it's possible. But most private placements, they're not taking advantage of the general solicitation,
Right.
so they really shouldn't be. They're not going to be disseminated widespread publicly. But I mean, there certainly could be situations where, insider trading.
Wait at the root of it or something like that.
Yeah.
So, okay, that's enough. I understand. That clarifies my questions. Thanks.
Sure, no problem. Alrighty, so we're going to move on to Gramm-Leach-Bliley. So Title V of the Gramm-Leach-Bliley Act protects the privacy interests of consumers of financial services, including clients of SEC-registered investment advisors, and this will also apply to state-registered advisors, as a lot of states incorporate by reference SEC rules. The SEC rules implementing the statute protect only individuals' personal privacy interests and not those of businesses or individuals who seek to obtain the services of an advisor for business purposes. So one of the things that comes up out of the Gramm-Leach-Bliley Act are privacy notices. And privacy notices, there must be an initial notice and then an annual notice. Generally, that annual notice, we recommend sending it with your annual amendment because you're already having to send that out every year, and it's just easy to tack on your privacy policy. The notices must be clear and conspicuous, which means they have to be reasonably understandable and designed to call attention to the nature and significance of the notice. They have to include, amongst other things, categories of non-public information that the advisor collects, categories of information the advisor shares, categories of affiliates and non-affiliates with which the advisor shares the information, and then the advisor's policies and procedures for protecting that confidentiality and security of the information. The SEC has actually adopted a model form that advisors may choose to use to satisfy these requirements, and the use of the form actually provides advisors with a safe harbor for the content of the required notice under privacy rules. So I'll actually be sending you guys links to the sample form, the associated SEC release, and instructions on using the form builder if you should choose to do so to update or otherwise change your privacy notice. So we've talked about insider trading, information we have from companies. Another kind of information we want to protect is client information. So an advisor must adopt written procedures that are reasonably designed to protect client records and information and to dispose of consumer report information properly. Non-public information includes personally identifiable financial information, and then any list, description, or grouping of clients derived using that personally identifiable financial information. So think of your client list as being non-public information. Personally identifiable information includes information a client provides an advisor, information that results from the services the advisor provides to the client, and then any information that an advisor otherwise obtains as a result of them providing those advisory services to the client. Non-public information does not include publicly available information, so information the advisor reasonably believes is lawfully made available to the general public from government records, widely distributed media, or any sort of disclosures to the general public required by law. So kind of like with the insider trading, anything that's widely distributed, widely disseminated to the public, that's available publicly you are going to be able to use. It's not considered protected information. So we have to provide, advisors have to provide clients with an opportunity to opt out or block the advisor from sharing non-public personal information with non-affiliated third parties. There are some exemptions where an advisor does not have to provide an opt-out, and that's for information that's provided to an affiliate, information the advisor shares during the course of providing advisory services to clients, so with a broker, transfer agent, custodian, lawyer, etc., with the client's consent or as required by law. And generally in those situations, your client's already signing, custodial documents with that other entity. And then the advisor shares information with a non-affiliate that performs services, including marketing for the advisor. Then in that circumstance, you must have entered into a contract with that non-affiliate that prohibits the non-affiliate from using the information except for the purpose for which it received it. So you don't have to provide an opt-out if you're giving information to your marketing affiliate, but the contract with that marketing company has to say that they're not allowed to use that information beyond the purpose of marketing or whatever service they may be providing your firm. So moving on kind of to the supervisory procedures we have to consider in light of the insider trading and safeguarding client information. So we had our privacy policies. We also have our code of ethics. So you're required, again, to establish, maintain, enforce written policies and procedures that are designed to protect and prevent the misuse of material non-public information. So a lot of the time, this information is included in the code of ethics. And so in order to prevent unlawful training and promote ethical conduct by advisory employees, advisors' code of ethics should include certain provisions relating to personal securities trading by advisory personnel. So, Dave asked the question earlier, what kind of circumstances would this come up in terms of implementing and having an insider trading issue? And it's going to come up in these kind of situations where you have access persons that are allowed to have personal securities accounts. And this is why in your code of ethics, you want to require that your access persons are reporting their personal securities transactions every quarter. You want them to submit a complete report of the securities that they hold at the time they first become an access person, and then at least once a year after that. You want to make sure that these personal securities transaction reports are actually reviewed either by a CCO or the CCO's delegee. Your supervised persons, they have to promptly report any violations of the code of ethics to the CCO or their delegee, and then you want to maintain a record of these breaches. You want to make sure that your supervised persons know all these things by ensuring that they each get a copy of the code of ethics and then requiring that they have provided you with written acknowledgement of receipt of the code of ethics. And I would go so far as not just receipt, but also saying that they've read, reviewed, and understand the code of ethics. And then, of course, you have to describe your code of ethics in Form ADV Part 2A, and then provide a copy to any client or prospective client upon their request. So that's how you're communicating, safeguarding information from an insider trading perspective, but also we are going to be also safeguarding client information through your privacy policy. So giving those and making those available to clients and prospectives. And then beyond that, okay, we've got another question. Okay, Dave, go ahead. Oh, sorry.
Sorry, on these quarterly reports about their trading activities, what's the best mechanism to make sure that they actually are providing them other than harassment and pestering? Like, can you say you'll get your quarterly fees payment as soon as we get your report, or does that create a problem, or how do you just ensure that they're doing that in a timely manner?
You'll want them to, whatever custodian or broker they're using, you want them to have duplicate statements sent. That's probably one of the easiest ways, and that way that's kind of happening automatically from the custodian to you as a CCO. Of course, you also want them to actually document and sign off, these are the accounts I have, these are the custodians they're held with, and then making sure that they submit paperwork where they're authorizing the custodian to send duplicates of statements, so you're receiving those. And of course, you want all of this documented, so if some way you find out that they didn't completely disclose all of the accounts and you found out, you can then refer to this written document where they signed off that these are all the accounts I have, and etc. That's certainly one easy way to handle getting copies of those transactions. I mean, certainly you can make it a policy that that their fee that they're the fees that they've generated, they won't be received until you get these documents from them.
So that doesn't create a conflict to do that. I mean, not necessarily saying I would do that, but that's one mechanism you could use to motivate them to provide it in a timely manner.
Certainly, I mean, that's up to your discretion, yeah.
Okay.
Right. You can't unfairly withhold, salary and stuff like that, but you can say that's part of the
process.
Part of the process, yeah.
And these, if they are trading, if they have accounts that are within the firm and at the custodians, they don't need to report on those because we already have that information. It's the ones that are external and outside of our strategies or our custodians.
Yeah, I mean, if you already have access to the accounts that they have with your firm, so if they're trading through the portfolios that you have, you already know what they're in. So yeah, the concern's really with these outside accounts that they hold elsewhere.
Thank you.
Sure. All right, so beyond the code of ethics, what else do you want to be asking yourself if you are the CCO to ensure that you have policies and procedures in place that are going to address these potential issues? The example I have here is handling of non-public information. So do you have effective processes to identify, contain, and prevent unauthorized and or inappropriate use of non-public information when it comes into your possession? What is the procedure for dealing with that? If your employees come into possession of that kind of information, is it identified, documented, and then contained? What do you do with that information? If we have a client that has a certain relationship with an issuer and one of your employees comes into possession of non-public information because of that client, how are we that information so it's not used to unlawfully trade in other instruments of the issuer. We want to look at other areas where we're going to be asking questions about, safeguarding client assets, looking into custody practices, providing information to clients, forensic testing, conflicts of interest, disclosures, and information handling. Now, I'm going to be sending all of you a few documents that provide multiple questions for different areas you should be considering in your compliance manual. So that will be kind of in a separate email to you guys because they can be a little bit lengthy, the number of questions that you should be asking yourself. But you do want to make sure that to the degree you allow certain activities or to the degree that your employees are allowed to have private securities transactions outside your firm, you want to make sure you have the policies and procedures in place to safeguard any non-public information that they or your firm may come into possession of. And that you want to make sure, again, the liability issue comes when you have possession and then use it to your benefit or use it to your client's benefit. So if you come in possession of it, how are we containing it? How are we keeping it private? So that is the end of today's presentation. It's just meant to be kind of an overview of insider trading, non-public confidential information of clients, and how to safeguard them and your requirements from a compliance perspective. Were there any other questions before we end the presentation? Okay. Well, I will be sending out an email shortly with a recording as well as the documents I've referenced, so the SEC form, privacy policy, along with instructions on how to use their form builder, and then the documents related to questions you should be asking when it comes to your compliance policies and procedures and whether they address some of the issues we've discussed today. If you have any other questions that come up later regarding the material we covered today, do not hesitate to contact us. You can email compliance@myralawyer.com, and it comes to myself and the rest of the compliance team. And you can always give us a call at 770-462-2118 to discuss any urgent or sensitive issues that may have arisen because of this presentation. Otherwise, we look forward to talking to you guys next week. Thank you.